Good afternoon, everyone, and a very warm welcome to today's webinar on war, political risk, and loss of investment claims. Over the past few years, geopolitical instability has shifted from being a distant strategic concern to a direct business reality. From the Russian Ukraine conflict to tensions in the Middle East, disruptions in global supply chains, sanctions, expropriation risks, and sudden regulatory actions have significantly altered the investment landscape. Businesses today are not only managing operational disruptions, they are increasingly navigating complex legal questions around treaty protection, contractual rights, arbitration, and recovery of investment losses. Against this backdrop, today's discussion aims to explore how legal strategy, commercial decision making, and dispute resolution intersect when investments are affected by war and political instability. We are very fortunate to have with us three distinguished experts who bring deep experience across arbitration, cross border transactions, infrastructure, energy, and international investment disputes. Very much welcome Abhisar, Yogesh, and Divim. Abhisar, let me begin with you. So, you regularly advise clients across infrastructure, energy, and construction, sectors that are often among the first to feel the impact of political instability. So, how does war and political upheaval usually turn into an actual legal dispute?
Thanks, Divya. Thanks for having us over. Let me start with a controversial statement, okay? Let me just say that um, war, more often than not, uh, exposes the, say, fault lines which already existed in a commercial relationship, then start a dispute from scratch, okay? And I'll let that sit with you and I'll come back to you. And see, any infrastructure project, it works on certain assumptions, right? And the assumptions are that the material will cross borders, that the banks will process the payments, the employees will be able to travel freely, the permits will, say, remain valid, and the governments will continue to honor its commitments, right? Now, war ends up challenging all these assumptions. And typically, as I can think of, it happens in four ways. So the first one would be the very obvious one, the very physical interference with an investment. And I think the prime example that we saw in the recent times was the Russia-Ukraine conflict when Russia took up Crimea, right? And what we saw happen was that, the oil and gas infrastructure, the energy facilities, etc., everything, the invasion caused all these foreign investments, they were all rendered unusable. They were all, they suddenly lay in occupied lands and they were all rendered unusable. Now, some investors lost the legal title altogether, and some retained the legal title, but their investments became practically unusable. Now, in investment claims, we call them by two different names. It's either direct expropriation, which is the former case, and something that we call the indirect or a creeping expropriation, which is the latter claims, right? So they did end up generating numerous investment treaty claims. The second pathway or the second kind of impact that I can think of is when there's a government intervention. Now, in times of conflict, there's almost always some kind of emergency that gets triggered in terms of governmental powers also. So governments end up suspending licenses, taking away subsidies, freezing assets. There are export controls, import controls, permits get revoked, etc. Now, from a government's perspective, these are all public interest measures. But if you look at it from an investor's perspective, they actually end up being breaches to contractual obligations, right? So that is the second kind of things that I see, the impacts that we've seen. A very good example of that would be the Devas Antriksh conflict that we saw in India. Now, of course, that didn't really arise out of any armed conflicts, but the typical impacts were all there because the government terminated a satellite spectrum agreement, it was called, and the arbitrations followed. There was an ICC arbitration. There were two BIT, treaty arbitrations, which also happened, came from Mauritius, came from Germany. So that is the second kind of intervention we see. The third kind of impact that we see is the fact that the money stops moving. The money stops moving, whatever work you've done, you don't get paid for it. That is also a very, it's a huge problem because, suddenly your credit notes become unservable, the bank guarantees do not matter anymore. So all these issues are also, I'd say, you know, it's the third kind of impact that I've seen. And then coming back to my controversial statement that, it actually just, uh, shows up what were the fault lines already. I say that because a number of times it so happens that the impact of war is not very sudden. It comes in slowly. It's not like the war happens and suddenly somebody, raises their hand and says that this contract can't move anymore. It's felt slowly. So anything that was already delayed might get more delayed. The resources which were already not getting uh, they were not already moving, they just become slower. So the routine clauses that we have, the routine claims that we have, they just become more and more complex because of war. The same prolongation claims, the same delay claims, disruption claims, they get more and more complicated. So I think these are the four ways in which I can think of that wars actually impact infrastructure and construction contracts, right?
Thank you, Abisa. That provides a very useful legal perspective on how political events evolve into formal disputes. But before a dispute even reaches lawyers or tribunals, companies themselves are often dealing with immediate operational and commercial challenges. And since Yogesh works at a ground level, let me bring you into the discussion, Yogesh. When political risk suddenly becomes real in a market you operate in, what actually happens first inside the company?
Uh, okay, first of all, thanks for inviting. I think from a company's perspective, it's not, we have basically need to look at the situation at multiple levels. Uh, we probably would have exposure in terms of the ongoing contracts over there, ongoing commitments to suppliers, some technology agreements or distribution agreements. So those sort of commitments. Plus, we may have situations that we may have employees out there, who are still working. We probably would have ongoing sites, which are still sort of, going on, and we are supposed to sort of continue and if we have ongoing sort of some commitment to the customers on that front. So from a when it so when something of this sort of happens, so the company basically looks at it from multiple angles, not just necessarily in terms of the projects or contracts or investment. And when and the company's expectation generally, it's not like we are trying to tackle one situation. Uh, Although, like for example, we sort of talked about the Russia situation. Uh, in those situations, of course, as a EU company, we knew that we're supposed to assess what's there out there and figure out whether we are legally required to do something or legally required to stop certain activities. One. Secondly, do we need to freeze any assets or what needs to be done in terms of the payments to employees or the vendors, right? Uh, that's one. Thirdly, also look at whether we have option to exit any commitments, right? But while we're doing that, we also have to look at the larger picture. That as a company, you may want to eventually come back to this market sometime in the future. So you want to also maintain that credibility of your company, right? So that's why when something of this sort happens, you typically get in touch with uh, all the major stakeholders, not just legal and compliance. It can be HR, finance, operations, the business leaders, and basically try and understand what is that we're going to do as first step and what is our long-term strategy towards that country or the region, right? So we look at it from a holistic perspective, and that's how we sort of take steps. from a purely contractual perspective, of course, as lawyers, you're supposed to look at what is there in your contracts and what sort of provisions allow you to either suspend or wind down or potentially exit or terminate the contracts. That's typically, eventually, as a lawyer, one would look at the contracts at least. But being a legal counsel in the company, you're of course required to look at it a holistic perspective. So, for example, what's happening in Middle East, uh, it may continue for a certain period of time, but eventually it's not a market which any company can ignore, right? So you need to have a strategy X for a certain period of time and strategy Y. Eventually, what's the long-term goal, long-term goal? Uh, as a mining company, equipment provider for mining companies, we often operate in very difficult areas. And typically, we do take these risks into consideration even before we step into any contracts. But uh, as I said, you know, we'll discuss more about that later. But typically, as a company, we would like to see the whole picture or the holistic picture. And for that, first of all, a team will be formed, and then we will decide the strategy, how to sort of respond to a certain situation. So it's not like just one department or one project manager addressing one situation at a time. So it depends on what kind of risk we are sort of tackling eventually. That's how we look at it.
Right. So, very interesting insight into how businesses respond in real time. Many of these investments span multiple jurisdictions, making the whole legal landscape considerably more complex. So, Divim, this naturally brings us to the question of jurisdiction and treaty protection. You are active across India, England, Singapore, the IFC. When an investment loss spans several countries, how does an investor decide where and under which law to bring the claim?
Yeah, thanks, Divya. Thanks, Mason, for having me. Uh, I think I first subscribed to both Abhisar and Yogesh's view. It's just there's no cookie cutter framework here. Okay, there's no one size fits all because like global investments, by their very nature, they touch upon multiple legal systems simultaneously. You cannot have one solution around every situation. It has to be seen, like for instance, as Yogesh pointed out, you need to see whether you want to go back in that jurisdiction. What are the existing relationships that are going on? To answer your point, I feel there are multiple factors you need to keep in mind while selecting a particular jurisdiction. I think to start with, I mean, the first thing I ask the client is, what is the legal basis of your claim? Is there a treaty behind it? Is there an investment agreement? Do you have any legislation to follow? Even for that matter, do you have a contract? This sets out the tone for the rest of the discussion. After that, the next obvious question that comes is which forum should we select and whether there is any strategic backing around it. You cannot take an emotional decision. I mean, we all have seen more often than not the place where the loss actually occurred is the least suitable place and it's not the best place to litigate. So you have to at that stage evaluate things like neutrality, enforceability, procedural efficiency. uh, I mean, for that matter, whether you can in that particular jurisdiction recover against a sovereign. I mean, take the example of Abhisar forward about Russia-Ukraine war. Can you actually recover against Russia? And classic example is that Yuko's case. The arbitration was done very efficiently, but enforcement took ages to complete. So that I would say is the second factor I'll look at it. Third is on the corporate structure. And this is more towards my friends who are there in the structuring world. There are very innovative vehicles and structures which are put in place. Your investments are routed through Mauritius, Singapore, Dutch holding vehicles. And this is not just done for tax efficiencies, you have to do it for sometimes treaty access as well. Another example is that you have a lot of my clients in India they are using Dubai as an intermediary hub to facilitate operations in Africa. That again is another model. So if a dispute arises in such kind of a investment contract, then which jurisdiction is the right jurisdiction? So and I mean, why should we go far? Vodafone is a classic example, and it's a classic lesson on how corporate structure interact with sovereign power. I mean, while it was a case of an inbound investment dispute, but the principle remains the same because Indian companies invest outward also would face a similar kind of a situation in another jurisdiction. Another aspect, I think, and it's very, very important, and where even for that matter, Mason comes into play, is the enforcement reality. A client, in my experience, rarely celebrate awards. They celebrate recoveries. Before you start thinking about merits, I always ask them, assume we win, where is the money going to come from? And that becomes, I think, the fundamental question. I mean, from my experience in practicing in all these global jurisdiction, the best jurisdiction is rarely closest to the disputes. Is one that gives you a legal right to actual recovery. Client comes to me, asks me, where do we stand? I say, that we'll pause it for a moment. Let's see whether you throwing good money after bad. Will you be able to recover your dollar out of this entire exercise, or are you going to just have a paper degree in your hand? So that becomes another important factor. And lastly, I think you have to select the right forum. You need to find out I mean, because there can be in these kind of investment disputes, there are multiple stakeholders that are involved. There is a country which is the investor. There is a financing coming from another industry. Asset may be lying in a third one. There may be the respondent state is holding somewhere altogether differently. So you have these are all moving pieces. You need to bring all of them together and ultimately see that the timing of your dispute, whether you'll be able to within a short span of a period going to recover your dues, and ultimately are you going to achieve the recovery or not. These are the factors I look into when I advise clients.
Rightly said, Divyam. So once the jurisdiction is determined, attention often shifts to the underlying contract themselves. Infrastructure and construction projects in particular rely heavily on these contractual risk allocation. So my next question is to Abhisar. So in construction and infrastructure especially, contracts lean heavily on force majeure and change in law clauses. When conflict hits, how well do those clauses hold up?
The short answer is that they work, but only if the drafter had enough imagination. When I say imagination, I don't mean just the imagination to know that these can get triggered. Imagination that the clause, when it gets triggered, will be broad enough to cover whatever kind of risk that we are looking at, right? Now, see, force majeure clauses, I think they got their biggest fame during the COVID phase, right? And we always joke, we say that force majeure clauses are like smoke detectors. Everyone assumes that they work till there's actually a fire, and then that's when you get to test it. And these are something that we call the boilerplate clauses, right? The cut copy paste clauses. And once you've negotiated a huge contract, nobody really wants to fight about these, especially for things which are not going, you really don't know that they're going to happen. Now, having said that, okay, we usually rely on, as an infrastructure contracts in India and elsewhere also, FIDIC is the one which kind of holds the most ground here, and almost all projects are always based on the FIDIC clauses. Now, since that dominates the space, it's reasonably robust, if you ask me, but it imposes a very demanding hurdle, which is that it has to be there has to be a prevention of work, and it doesn't say that the work became slower because of the force majeure event, or it became more expensive, or it became, say, inconvenient. You have to say that it actually prevented you from going ahead and doing something that you were supposed to do under a contract. And this distinction becomes really enormous because wars rarely stop the projects overnight, like I said, right? Because the disruption is usually gradual. The supply chains get interrupted. There are labor shortages suddenly. There's a restricted access, or maybe, the costs rise beyond a certain point. So I think the good ones, the ones which survive, are the ones where the parties have somehow negotiated away from these default clauses. So where they have actually lowered the threshold from a prevention threshold to say, uh, go for, the things where it has become very expensive. It has become something that, it's not viable in terms of, going ahead with this project. And there's also have to, there's a distinction where you have to draw between what are the compensation events and what are the relief events. I'll explain it to you, because the default is usually that if there is something that happens, if there's an event of force majeure that happens, then the default says that you'll get additional time to perform it, right? And you'll get additional time to make good the loss that you might have suffered during the existence of this force majeure event. Now, a smarter thing would be to have a compensation instead, because if there is a war, you might not be able to come back and perform it. What Yogesh said, that, is it even a place where I want to go back again and perform the contract or the rest of it? Okay. So in situations like that, when you really want to just get away from that place, it really becomes important that what kind of a uh, force majeure clause did you end up negotiating. Another thing is that the FIDIC contracts have this procedural hurdles, where they say that if you miss sending out the notice within a certain period, 14 days, I think it is, then you have really missed the bus. So you might have the most legitimate claims, but you'll sit pretty with them because you can't do anything about it. So, that also impacts. And when it comes to, say, change in law clauses, okay, that is another hurdle that we always see, because change in law is it deals with a different set of problems, because now it has to respond to regulatory changes. And the regulatory changes which come about in wars, you're looking at sanctions, you're looking at emergency regulations, you're looking at control of money, you're looking at export restrictions, and all these come in at last moments. You response time to it. So again, the success depends totally on how you've drafted and how broad you've made them. What do you consider as unforeseeable event in these situations? Because see, if you've actually gone in an area which is prone to conflict, then how do you show that this is an unforeseeable event which caused this, which triggered this change, or this change in law? So I think it all depends on how well they are drafted, how far you've been able to negotiate, and how imaginative you've been. It's totally the drafter's foresight which really comes into play. So as a dispute lawyer, I'm really happy that I'm not the one who gets blamed at that point of time. But yeah, if I look at it from a client's perspective, then yeah, frankly, it's all a lot, to a lot extent, it is already decided when it is first put on paper.
Correct, correct. I really like your anomaly used for force majeure clauses, smoke detectors. So that's a great point on how contractual clauses perform under stress. Of course, the effectiveness of those clauses often depends on how thoughtfully they were negotiated and drafted in the first place, which brings me to the next question to Yogesh. So you might have closed cross-border contracts worth hundreds of millions. So at the drafting stage, which clauses genuinely protect a company when political risk hits, and which gave false comfort?
Okay, so Divya, when we talk about political risk, we're basically talking about political risk converting into financial risk, right? So typically, whenever a company like us gets into any negotiations or conversations, uh, we sometimes either do anticipate that, okay, there can be potential issues at a certain project, or sometimes it can be completely something which we cannot anticipate or expect. Right. So there are these two situations. Things which we can potentially anticipate or say that there is a high probability of some things happening. Then we have a certain different strategy. Like we do basically specify very expressly in the contract that what happens if the contracts were to get suspended at a certain point of time, or what happens if the contract were to get terminated at a certain point of time during the project phase. Uh, those are the ones which are, wherein we believe that risk is slightly manageable, where we know that there is a possibility of something going wrong. So, for instance, I think Metso is quite heavily involved in recording project, which is basically in Balochistan, in the Pakistani province. Now, when we started negotiating that contract, of course, all of us knew that it is a rusty province and there is always a potential of something going wrong there. So our approach to negotiations was slightly different, and we knew that there are certain protections which we need to build in the contract, right? But where situations wherein you could not anticipate anything, in that, of course, you just negotiate basis uh, uh, what can probably go wrong, and and also best case scenario. Uh, so yeah, I mean, it's basically, from a legal counsel who's working in-house, I think for us, it starts from assessing the project, first of all, who the owners are, where the project is located, where the money is coming from, what is the potential of financial default, or whether there is a potential of the license, the company losing the license of any mining lease, or losing the mining lease, for instance. So basically, we look at it from a different, on all the perspective that, okay, this is, first of all, we assess the project and the company. And then we basically start negotiating what is needed to be done. Uh, and because, many times we may come across a situation that you may not always be in a position to negotiate everything what you would like to, right? That's always a possibility. So always focus on what is your must-haves, what is that you definitely need in the contract. And as an in-house lawyer, I think uh, it's a quite a heavy burden on us also sometimes to basically figure that out. But typically, as I think Avisa quite rightly said, that when you negotiate a force majeure clause, for instance, uh, you I think you should not look at it as a boiler, just like and just any other boilerplate like provision, because especially if you are working in difficult uh, setups, right? Uh, as you rightly mentioned, that force majeure typically, the way it is worded, it is interpreted in terms of a prevention of certain commitments. Then obviously, it's not really a very useful provision for you. You need to be very careful how you draft that provision. Otherwise, it is, of course, very difficult to use it many times. In fact, we've seen that situation happening during this recent Middle East war as well. Sanction clause is another one which we typically nowadays are very careful about putting them in, because it is becoming very common, especially for companies which are based out of EU or US, or even companies who have operations over there. I think they need to look at that provision more carefully, and whether you not only have a right to suspend your performance, or can you actually terminate the contract in the event any sanctions sort of you kick in, and what are your rights to get compensated for that, right? Uh, Something like a termination for convenience, that's another interesting provision which we'd like to have in the contract in case we are working in a difficult area, where we can actually predefine, and sort of pre agree with the client, or the counterparty that what would be the compensation which would be paid out in the event something were to go wrong, and at what point of time it goes wrong. Uh, so yeah, so multilateral adverse change, I think that's a very common provision. I think that just like change in law. But as Abhisar was quite rightly mentioning that, it depends a lot on how you've drafted these provisions. Uh, you need to be extremely careful, otherwise, uh, these can actually cause a false sense of comfort. Uh, but eventually, if it comes to using them, it may not be that useful. And as a company, we have come across those situations more often than we'd like to. So, yeah, so I think the drafting matters a lot. Uh, yeah, so this is how, as at least from a company perspective, we look at it.
Right. Thank you, Yogesh. While contracts provide one layer of protection, international investments frequently rely on an additional framework, which is investment treaties. So, Divim, my next question is to you. Do existing bilateral investment treaties provide an adequate legal framework for resolving investment disputes arising from wars and international sanctions, or is or is it or is treaty reform necessary? What do you think?
Yeah. So the current BIT regime we have, they lay down foundational protections for sure. Fair and equitable treatment, full protection of security, conflict safeguards. But we must appreciate that most of them were drafted in the 80s and 90s, when interstate war disrupting global investment, it was really an academic discussion at that point of time. Today, the rules of the games have entirely changed. We have seen sanctions, export controls, technology embargoes. I mean, these issues can render any investment worthless without destroying a single physical asset. Consider this as an example. Indian company, fully FEMA compliant, invest in Iran, and a foreign military strikes, destroys its assets. The host states says force majeure. There is no, by the way, there is no BIT claim against the attacking state. India does not have a BIT with Iran. So the investor is actually in a legal no man's land. So these kind of complexity, these kinds of nuances are not something which are factored in the current BIT regime. I would say there are three gaping holes or gaps, I would say. First is there is no safe harbor for genuine state security measures. That's not, at least in my understanding, it's not there. Then most of these BITs are unclear on rule on whether state-owned enterprises qualify as protected investors. That again becomes a big shield for most of these state-owned enterprises. Third is whether this traditional war loss clauses, which basically deals with civil unrest and other issues, they don't now deal with issues like interstate wars with third party bombarding and proxy conflicts which are happening. Again, the clauses doesn't provide for it. They were never designed to cater to such situation. To answer your point, reform is very much needed. I'm not suggesting let's throw the BIT framework out. Most of it remains relevant and valuable, but reforms are very much needed. India UAE BIT of 2024 is a step in the right direction, but we need a political will to overhaul the entire framework across regions and look at the commercial reality now. We are living in a very, very different world, which was there even 10 years earlier. People have never heard of something like a COVID. Again, that is another issue which created a huge impact across the globe, and none of the BITs actually ever factored such situations in. So yes, reforms are needed, but it has to be in a more thoughtful and a strategic manner and must comply to the commercial realities of today's world.
Correct. That gives us a very good understanding of your opinions. However, obtaining a favorable award is often only part of the journey. Enforcement can present an entirely different challenge. So, Abhisar, you have written on the enforceability of arbitral awards in India. Once an investor wins an award against a state, how realistic is it to actually get paid?
Not very. No, don't quote me on that. But like, it is an uphill battle. It's like, I think getting the award was only act one, scene one. There's an entire play after that, which is how to get the money out. And like what Divyam said in the beginning, you don't really need a paper decree. You actually want to see the money, and that's what the clients want, right? So now, obviously, we are not signatories to ICSID. ICSID has a very self-contained enforcement procedure, etc. It has its own regime, which is, it requires the contracting state to recognize the ICSID award as binding, and then it gets enforced as if it was a final judgment of their own court. But that doesn't happen in our country because now we have to fall back on New York Convention. And we've adopted the New York Convention with two significant reservations. One is of sovereign immunity, and then another one is whether it was a commercial, it was considered commercial. The entire contract, the entire arrangement was considered commercial. And those two actually can wreak all kinds of havoc. And we've seen all of it unfolding in Devas and Antariksh over the years. So it's interesting because firstly you have to get over the hurdle of what is sovereign immunity, right? Do we have a sovereign immunity? If this was uh, and in that case, especially when they said that this was all about you're looking at national concerns, you're looking at a security concern, whether a spectrum can be used, ISRO's spectrum can be used by another Devas, which has investments from Mauritius and Germany, etc. Also, there was a patent illegality found in their contract, which was upheld. So, in a situation like that, I think that's the first hurdle which comes in. And the second one is is it something which is a commercial contract? Because, usually investor-state disputes in our country have been termed as a non-commercial contract. So if it's a non-commercial contract, how does that work out? And one of the things that was being claimed in the Antriksh Devas thing was that because India actually was participating in the dispute, that means that they've actually waived their sovereign immunity. But then that also got set aside. A UK court said just because they were participating does not really mean that they were actually waiving their sovereign immunity, right? Or the commerciality. So basically, what has happened at this point of time is that they have, I think, 3 awards in their favor, and none of it has been able to, get any money for them. So I think it really becomes important. And then, we go back to what Divyam and Yogesh was saying earlier, that you really need to look at where exactly, your assets are, where exactly are you going for contracting, where are your companies which are going to claim, where are the assets that are going to be claimed? Because the second issue that becomes important is that even if you get an award, even if you can cross over these hurdles of what is sovereign immunity, whether it's a commercial contract, what are the assets of the state? We have to look at the commercial assets of the state. So now, what does it own? And what is it? The airports? You're going to take away the aircraft? What are you going to take? And once you go into what are the commercial assets, then there's another third question which starts off, because all these assets, and it's actually interesting that in practice, governments rarely keep any commercial assets sitting very neatly in their own names. So now they may be owned by a PSU. And then this PSU, is it another legal entity? Is it, are you going to pierce the corporate veil and ask for the assets of this PSU? So all these issues become really important, and that's where we need, all kinds of investigations. That's where we need all the experts to step in even before we go into a dispute. So yeah, I would say that for any sophisticated investor, um, the parallel enforcement, as in whenever you're you feel that there is a dispute which is going to arise, then I think even before that, you really need to look at that where are the commercial assets, where do they exist, which are these countries, etc. So I think the practical takeaway is yes, that this is sometimes, more often than not, this is actually a more uphill task to get the money out of it uh, than winning an award, frankly. Yeah.
Right. Thank you, Basar. That was an important reality check. Enforcement against a sovereign raises issues that are very different from a commercial arbitration. So, Divim, my next question is to you that investment treaty claims are brought against the state itself. Strategically, how is taking on a sovereign different from a normal commercial dispute?
I think the equation changes entirely. When you are dealing with an ordinary commercial counterparty, the ballgame is absolutely different from when you're dealing with a sovereign state. In a commercial dispute, you just prove breach of contract and move on. In an investment claim, you must show a sovereign cross the line from legitimate regulation to do an internationally wrongful act. And trust me, it is easier said than done. It's just not easy to establish. So it's sometimes we as litigators are very happy dealing with commercial disputes more than the investor state dispute, knowing the fact that at least there is a set boundary, there is a sort of a fair play between the parties, because it's not in my experience an arm's length uh, dispute. There are, I would say, 3 or 4 factors which one must keep in mind. States enjoy sovereign immunity. So you need to find commercial assets, state-owned enterprises in trade, commercial accounts, shipping vessels, as Abizar said, aircraft for that matter. I mean, India lacks a dedicated sovereign immunity statute. So most of the time, people go to England, Singapore, where law is more nuanced and developed. A classic example is the Kane Energy dispute. I happen to have been advising one of the state entities having a significant exposure globally. That state entity had nothing to do with the dispute, was not even involved, but they had exposure across the globe. And the way Kane Energy was moving around, obviously it was a real risk for that entity as well. So one needs to find that strike the right balance. The second is access to evidence. Most when you deal with these issues, most of the evidence is the government records, what happened in their internal meeting, was there any kind of a ministerial correspondence? All those documents sit with the state. And when you go for it, you'll not find most of this information. It becomes a Herculean task to recover them in any form of discovery. And you end up relying on public materials, which may or may not have all the accurate information. So again, the access to evidence becomes a huge challenge. And the last point is more on the sovereign defenses. I mean, a state can easily take shelter under national emergency, essential security interest, necessity. It's a different playbook altogether. I mean, I even for that matter in India, we are seeing that kind of a playbook happening on a regular basis when you don't know what is the definition of these terms, but national security, national emergency is good enough to carve out a different story altogether. Even there was an Argentina crisis where LG&E and CMS gas was involved. The bar was set so high you cannot anticipate what kind of a defenses can come your way. So I would say the takeaway is that enforcement strategy begins at the first client meeting, not after the award. I subscribe to the view what Abizar also said. I mean, I'll share an anecdote, though it pertains to more of a commercial matter than an investor state dispute. But my client got a foreign enforcement judgment. They tried to enforce it against a party in India. One of the assets that was listed during their transaction, they tried to, we got a court order to attach that property. When we reached there, we found it was a temple. So clearly, you need to do your homework very well beforehand. And when it comes to investor state, do that homework like years ago.
Correct, correct. Thank you, Divyam. When governments become counterparties or even respondents, the legal strategy must also account for diplomacy, regulation, and ongoing relationships. So, Yogesh, your work involves engaging government and regulatory authorities across jurisdictions. When the host government is effectively the other side, how do you manage that relationship?
I think one point which Divyam quite rightly said is doing your due diligence properly. I think uh, a lot of risk, you can actually try and address by at least understanding what you're getting into, right? So I think doing your proper DD of whom you're dealing with, right? Where the money is coming from, uh, what are the payment mechanisms, or what is the political situation in that country, what are the social situation, who are the ultimate owners, I think these are certain things which uh, would give you a lot of insight in terms of what you're getting into. I think, and doing that risk assessment is extremely important. Uh, but while dealing with government, of course, uh, the situation is already slightly skewed because you're dealing with an entity which probably has a better negotiation position to be. So it's not really always necessarily possible for you to negotiate the best deal, right? But again, focus on what you must need, must have from a certain deal, right? And that insight or that sort of idea you can get only by proper due diligence. That's extremely important. Secondly, I think it was discussed earlier also, we tend to rely a lot on what the contract basically says, right? Like, for example, a governing law provision. Um, I think most of us are quite comfortable when it comes to English law or Singapore or New York. But again, as Divya was rightly mentioning earlier, eventually what matters is that whether, you know, having a legal right is one thing, but can you really recover value out of having that legal right is what, what matters eventually. So whenever you're basically dealing with a sovereign or, an entity where you don't necessarily have a better negotiation position, I think you need to understand uh, that how much financial commitments which you're going to make, uh, which can potentially be addressed if, let's say, something were to go wrong. And can you structure the contract or payment mechanism in such a manner wherein you try and mitigate or minimize such risk? Yeah. I think that's one practical way of looking at it because, you know, as I said again, even if you have a legal right to recover, let's say, damages, that doesn't necessarily mean that you will be able to sort of recover the money. Yeah. So plan accordingly that, if what if things go wrong. Again, I think, and because you're dealing with the sovereign, I think there are certain restrictions, in terms of what you can do and what you cannot do. You have to, of course, be always respectful, depending on which country or which region you're working in. Try and understand what that entity is trying to achieve. I think so. For instance, as I was mentioning earlier about robotic project, there is definitely a payment crisis there. So it's not necessarily very easy for them to sort of make payments. Then how do you address that? Because you know that that's the situation. So try and understand where the government is coming from and what are their uh, sort of issues and what they're trying to achieve. Yeah. And try and come up with solutions which they can potentially accept. Right. Uh, Again, as I said, uh, having a contractual right is one thing, but giving a workable solution, considering what the other party is sort of getting into or going through, I think I would say the latter would give you better results. Uh, Again, but that doesn't necessarily mean, and I'm not at all advocating that we should anyway give up the legal rights. Protect it at all costs. Protect the legal rights, but be respectful and try and understand what they are trying to achieve and try and understand what their uh, shortcomings and issues are, and give a workable solution. Uh, and I think that might always help you. Uh, you know, because I think the governments do not necessarily want to get into disputes, but eventually what they're looking at is that they have many situations at hand. They have a political risk, they have a social risk, they have a financial situation, they have certain other stakeholders whom they're supposed to manage. So they have all sort of things which they're supposed to look out for. Uh, so when you're dealing with government, I think you need to have these things in at the back of your mind and understand what would give you better protection. Uh, and if you've done your due diligence and if you know that this is something what can go wrong, I think you can build in certain clauses in the contract. What if the contract gets suspended at certain point of time or terminates, of let's say, or there is a appropriation by the government, then you can address those specific situations in the contract accordingly. So do the proper due diligence, understand where the government is coming from, uh, try and give a workable solution, and address whatever, protect your legal rights, of course, and address the risk what you've identified in the due diligence in the contract as much as possible. I think that's what we generally need to do.
Very valuable commercial perspective, Yogesh. From there, the focus shifts to claimants' broader litigation strategy and the critical decisions that shape the case from the outset. So, Divim, your work often sits where legal strategy and commercial reality collide. In a war loss claim, what are the big strategic calls a claimant has to get right early?
I mean, I think the most disputes or most arbitration litigations, parties argue over facts. In war loss claims, parties first struggle to find facts. I was reading somewhere that in the Iran-Israel-US conflict, there were vessels which were there in Strait of Hormuz, and the vessel belonged to a uh, Greek shipping agency, and the asset that was lying there within the vessel belonged to a different country altogether. It pertained to a different commercial contract. Due to all this conflict area, the vessel was attacked. It was later on found out that the attack happened because of the US missiles. But imagine a situation like this. How do you marry the legal strategy and the commercial reality? How does one work around that kind of a situation? Who is to be held accountable for a situation like this? How do you assess your loss? What is the attribution that you can put, let's say, on US in this example? How do you generate evidence? Evidence would be destroyed by the time you make it to that area, and whether you will be ever able to make it to that volatile area for that matter. How do you quantify damages? So I would say it's a different ball game altogether. I would possibly few points that come to my mind which would be relevant is which jurisdiction you approach. Before assessing merits, you need to find out you have a treaty protection or not. You have to prove the damage. You have to see what is legally attributable to the state. Uh, One needs to find out whether there is enough evidence available. You have documentary evidence, satellite imagery, any other form of evidence, because that's going to disappear very soon and you'll not be able to recover it at a later point of time. Another important thing is, will you be able to quantify damages? and you will require a robust valuation methodology, damages analysis. I would say experts like Mason comes into play at that point of time. They can really change the dynamics of the game. You have insurance coverage or not? These are regular risks which are coming, and companies are getting cognizant of it. Do you have any kind of a third party funding? Whether the treaty permits you to have party funding applicability. There are various treaties, including Indian treaties, where third party funding is not available. And of course, as I would say the flavor of the entire discussion, enforceability, whether you have any form of or way to get your final decision or claim enforced in the right court of law.
Correct. Thank you, Divyam. Excellent insights. Ideally, companies would prefer to avoid disputes altogether. That raises an equally important question about prevention and preparedness. Abhisar, before a dispute crystallizes, what does good pre-dispute advisory actually look like for a company in a high-risk region?
If you ask Yogesh, I think his favorite dispute lawyers are going to be ones which just didn't let the matters reach the arbitration. Right. Yeah, he's actually nodding to that. So, yeah. So basically, yes, I think a lot of uh, work should start at a very nascent stage. I would say that even before the investment is made, I think there are some, checks and balances, and Divyam covered some of them, but I'd just tell you which ones that I think are important. Before you make the investment, I think it's very sound that you should check that, there should be a strategic nationality planning that where is your holding company? Is there a holding company in jurisdictions which have investor-friendly BIT networks? And I think that's what, something that you need to see, that it should be, the architecture should be around these countries. So the advisors must map what are the available treaty networks for the host state, and what is in it for the investor state, and then select it accordingly. I think that would be the first one. The second one I would say is when you are drafting the contract. I think that's one thing that should be looked into. All these boilerplate clauses that we were talking about, they will not survive a geopolitical shock. So the high risk projects and projects in high risk areas, they really need to be looked into carefully. Negotiated provisions would actually help, which will go beyond what I was talking about initially, the standard forms. So force majeure clauses, which enumerate, something like a political risk, and which should cover war, which should adopt the hindered situation and not just the prevented situation. Change in law clauses, which should address something like sanctions, specifically emergency regulation, specifically some kind of capital control, specifically, and probably have some kind of stabilization or clauses, or equilibrium clauses, what we call them, that economic equilibrium clauses are what we call them. So some of those should actually be incorporated. Then probably I'd say that there should be express waivers of sovereign immunity as far as it's possible. If you can incorporate it in your clause itself, I think that single clause will be worth more than any other protection that you could think of in investment disputes. Then I think the third thing is that, once the project kicks off, is the most non-glamorous part of a construction lawyer's work, is what we call feeding the file. Every notice needs to be sent out in time. All kinds of compliances need to be done. All kinds of government actions which are having an impact on you need to be recorded. If there is a disruption, if there's a delay, if there is going to be requirement for more manpower, idling, etc., everything needs to be recorded. Anybody who's been in a construction dispute would be able to tell you that, and I'm sure you, Divya, you would also have seen so many of them. So, what usually happens is that something else happened on site, and something else got recorded, and something else made it to the statement of claim, and and even lesser things made it to the evidence stage. So I think one of the most important thing in any of these disputes is how well it was documented. So I think that is important. Another thing that Divyam already mentioned is risk insurance. Specific political risk insurance is going to go to a great extent to safeguard. And this PRI must be secured before the risk materializes, because a lot of people try and start going for it once things start brewing, and that really never helps. So that is another thing. And finally, I think any good legal advisory would include keeping an eye on the horizon. You should know when things are about to get sour, and put in more money in avoiding the dispute would actually help later. Because even if you have a really strong ground, and I'm just saying things which are really damaging to both Divyam and me, but if you can pump in money at the time of avoiding the dispute, then it is going to be way easier than pumping the money and going through the dispute, then advisory later on how to get your money out of it. So I think of an eye on what are the legislative changes that are coming about, what are the security conditions, what is going wrong, uh, dealing with the local council, and just legislative pipelines and being on top of things. I think that would be real robust legal advice. Yeah.
Certainly, Abhisar. Finally, even where disputes are unavoidable, businesses still need to make commercial decisions about preserving value, accounting for losses, and planning their exit or recovery stage. So, I have a last question for Yogesh. When an asset or investment has to be written down or exited because of conflict, how does company think about quantifying and protecting that value commercially?
Um, so this is actually not a very easy question to answer, because it depends on various situations. Uh, like for example, in Russia situation wherein companies had to exit uh, from the country eventually. Uh, there were stages wherein you were sort of allowed to continue to execute your ongoing obligations. Uh, but after a certain point of time, you were supposed to wind down and exit. I think in those kind of uh, it's important for the companies from a company's perspective to sort of start assessing what would be your potential loss and where all you can actually mitigate it in the first place. Uh, and recover whatever value you could actually recover. From a management perspective, that's again very important. Uh, and lastly, if there is a future possibility of uh, sort of gaining some economic value out of your current work or whatever you have executed until the date, let's say a certain situation kicks in, try and protect that future economic value. So, for example, uh, for infrastructure project, for instance, can you protect the right to, let's say, or uh, or protect the right to supply spares in the future, even if you're executing a project at, let's say, at X point of time. That's one example. Secondly, I think if it is about investment, can you protect your royalty, future royalties on the product which are sold, something like that. So basically three things. One, how much a company can recover if a situation is sort of kicking in. Start talking to multiple counterparties or other stakeholders who are involved, your vendors, uh, your distributors, and figure out whatever economic value you can sort of preserve. One, uh, of course, as is the loss which is going to happen, and try and provide for it and save the economic value of the future. incomes which you can potentially get. Um, Apart from that, if the contract allows you, I think sometimes there are indemnities which can sort of give you certain legal rights to potentially go against the counterparty and try and recover potential losses. So have a look at your indemnity provisions. Uh, Look at your insurance program, whether you have insurance, which sort of protects you from political risk, whether it protects any trade disruptions, you know, if you've taken any reps or warranties, insurance, you know. So, for instance, if the customer has given you assurances basis that can you go back to your insurance and sort of claim that? So look at your insurance program. I think that will also sort of give you an idea of whatever you can recover. And of course, at the end of it, if you still wish to go against the counterparty and recover your actual loss or damages, the litigation is, of course, always available uh, to quantify your potential claims and start, your litigation strategy. Uh, so these are certain things basis which you sort of try and mitigate your losses, assess it, uh, and also try and preserve future incomes if possible. Uh, yeah, that's what I say.
Right, right, Yogesh. Thank you. So in the interest of time, we'll not be able to, I think, take the Q&As. Right. So I think that's all. Thank you to all our panelists for sharing such thoughtful and practical insights. Today's discussion has highlighted that in today's geopolitical environment, managing political risk is no longer confined to legal departments or boardrooms. It requires a coordinated approach that brings together legal strategy, commercial judgment, risk management, and international dispute resolution. I would really sincerely thank Abhisar, Yogesh, and Divyam for sharing their expertise and experiences. And thank you to our lovely audience for their time and engagement. Thank you. I think that's all.
Thank you very much.
Thank you.
everyone. Thank you
Thank
so
you.
much.
Thank you.